Preventive action of the police. Preventive action of the police means what the police officers will do to prevent the commission of the crime. So, police to prevent cognizable offences. So, cognizable offences are those offences that are very serious in nature. For example, murder, rape, all these are serious offences. So, there are two kinds of offences, cognizable offences and non-cognizable offences. Cognizable offences are serious offences, non-cognizable offences are less serious offences. When you commit a cognizable offence, the police officer can arrest you directly without the warrant of the magistrate. But when it is a non-cognizable offence, the permission or the approval of the magistrate is required before arresting a person. Okay. Now, section 168, every police officer may interpose for the purpose of preventing and shall, to the best of his ability, prevent the commission of any cognizable offence. So, they must try that in their locality no cognizable offence occurs. Okay. Now, information of design as to commit offence. So, section 169, every police officer receiving information of a design to commit any cognizable offence communicates such information to the police officer to whom he is subordinate and to whom to other officer whose duty is to prevent or take cognizance of the commission of any such offence. For example, design to commit offence. For example, someone has bought some poison. Okay, so the police officer has got a clue that this person is going to kill that person. So in that case, once he receives the information, he has to communicate the same information to his superior authority. Okay. Now, arrest to prevent commission of an offence. So a police officer knowing a design to commit a cognizable offence may arrest without the order of the judicial magistrate and without a warrant. See, in cognizable cases, the police officer has a power. They do not require the permission of the magistrate. Okay. The person so designing, if it appears to such officer that the commission of the offence can be otherwise prevented. No person arrested under subsection 1 shall be detained in custody for a period exceeding 24 hours. Please underline. So even if you are arresting those person, you cannot detain that person. You have to present that person before the magistrate within 24 hours from the time of the arrest, unless his detention is required or authorized under the other provisions of the Sahita or any law for the time being in force. Now, prevention of injury to public property. So, section 171, a police officer may of his own authority interpose to prevent any injury that is attempted to be committed in view of any public property, whether it is movable or immovable, or the removal or the injury of any public landmark, buoys, or any other landmark that is used for navigation. So, police officer will directly go and they will prevent the destruction of any public property. Okay. Now, persons bound to conform to the lawful direction of the police officer. So, all persons shall be bound to conform to the lawful direction of a police officer given in the fulfillment of his duty under this chapter. So, a police officer may detain or remove any person resisting, underline, resisting, refusing, ignoring or disregarding to conform with any direction that is given under subsection 1, and may either take such person before judicial magistrate or in petty cases release him when the occasion is past. So in some cases they can even release them by making sure that they will not repeat those crimes again. Now in Neelabati Behera versus State of Orissa, so in this case Suman Behera, the son of Neelabati Behera, was arrested by the Orissa police for investigation of an offence of theft. Theft is a cognizable offence. Then he was detained at the police outpost. The next day, his dead body was found on the railway track. So there were laceration of his body that indicated unnatural death. A letter was sent by Neelabati Behera to Supreme Court, who took suo motu action and converted it into a writ petition under Article 32 of the Indian Constitution. There was an inquiry made by the district judge which added evidence of multiple injuries being inflicted on Suman during the police custody at police outpost at Jerekela. So the police, however, argued in the petition filed by Neelabati Behra that Suman Behra had managed to escape from their custody at about 3 a.m. on night and between 1st to 2nd December. They argued that despite their efforts of searching him, he could not be apprehended, and thereafter his body was found on the railway track over there, which was a possibility of the train passing over him. The court noted that there was no logical evidence of any search by the police to find Suman Behra, and also it was reported by the railwaymen that the police reached much later to take the charge of the body, which raised a question as to their credibility of their statement. The injuries, according to the doctor's report, were caused by the blunt object, which also raised the doubt of lathi blow. So the Honorable Supreme Court awarded a compensation of 1,50,000 to the mother of the deceased and ordered a sum of 10,000 rupees to be paid to Supreme Court Legal Aid Committee. Also, the Supreme Court directed the state of Odisha to initiate criminal proceedings against those who were involved in the death of Suman Behra. So this is also happening. We often see custodial death happening. So when we talk about the power of the police officer, nowadays they really enjoy some excessive power, because of which